Good morning, everyone, and thank you for joining our session with our guest speaker, Professor Daniel Walters from Penn State Law. I'm Uben Zaou, and I'm delighted to say a few words about our program funded by the European Commission through the H2020 and Marie Curie actions. This month, our series will also feature two other speakers, namely Professor Michelle Oko from Duke University and Professor Smita Narula from Pace University. Also this month, we'll have our sixth annual North American Environment, Energy and Natural Resources Conference at the Inner Center. So please visit our website, www.law.uh.edu/inner-center, where you'll find the upcoming events in the series and also the past recordings and speakers that we had with great topics. Feel free to use the chat box for any questions. And in due course, we will be displaying the CLE credit slides. I'll now turn it over to Professor Gina Warren, co-director of the Inner Center and our chair this morning.
Thank you so much, and good morning. Good morning to everyone, or good afternoon or evening to whoever is watching this remotely later. But I am honored to introduce today's speaker for our webinar series. So Professor Daniel Walters is an assistant professor of law at Penn State Law, and he's also an affiliate faculty member at the Department of Political Science and affiliated researcher in the Institutes of Energy and Environment at the Pennsylvania State University. He brings an empirical and interdisciplinary approach to the study of public law and regulatory policy. And his current research focuses on empirically testing claims undergirding proposed reforms to the regulatory law, as well as examining approaches to promote the transition to a cleaner energy economy. Professor Walters serves as the editor-in-chief of Administrative and Regulatory Law News, the newsletter of the American Bar Association section on administrative law and regulatory policy. He's a graduate of the University of Michigan Law School, where he was a member of the Michigan Law Review and served as the editor-in-chief for the inaugural volume of the Michigan Journal of Environmental and Administrative Law. Professor Walters also earned his PhD in political science at the University of Wisconsin-Madison. And before joining academia, he was a law clerk for the Honorable Margaret McCowan at the U.S. Court of Appeals for the Ninth Circuit. Today, he'll present his most recent work, Grid Governance in the Energy Trilemma Era, Remedying the Democracy Deficit, which is forthcoming in the Alabama Law Review. So welcome to you, Professor Walters.
Great, thank you. I'm gonna share some slides. Thank you for the kind introduction. So yeah, can everybody see these slides all right? Okay, excellent. So I should say at the outset that this is actually co-authored work with an energy economist here at Penn State, Andy Cleet. Some of you may know him. He's written about energy markets, market manipulation, and capacity markets in RTOs. So he knows a lot more about RTOs than I do, the subject matter of the paper. So anytime I don't know an answer to a question or something, I will just find out what he would say and then get back with you. Okay, so I should also say at the outset that this project was funded by a tremendous outfit called RTO Gov. It's an interinstitutional collaboration to try to study governance in these critical institutions that I'm going to be talking about, very understudied institutions. So if you aren't familiar with RTO Gov, would strongly encourage you to check out their website. A lot of exciting things are happening around RTO Gov, and we're very thankful to have the support of RTO Gov for this paper. Just to dive right into things, the topic of the paper is about these kind of obscure institutions. Some of you may have heard of them, some of you may not have heard of them. They're called regional transmission organizations, or RTOs. There's also another related institution called an ISO, but the differences between them are not all that important for my purposes. So we'll just call them RTOs generally. And they're definitely not a household name. So I would guess that a lot of people have never heard of PJM or a CAISO or MISO or ISO New England. Maybe in Texas, some of you have heard of ERCOT because it's been in the news a lot lately. So that's another one of these RTOs, but they're very obscure organizations, private organizations, not agencies, not government decision makers, which is part of what makes them a really fascinating phenomenon to study. So what do they do exactly? Well, in a nutshell, they sort of effectively govern the grid, the electric power grid. So you can kind of think of them as sort of like an orchestra conductor. There's a lot of actors in the electric power sector, utilities, independent power generators, transmission line owners. All of these different players are coordinating on some level, much like individual sections of an orchestra. But the RTOs are sort of like the conductor that comes in and makes sure that everything is working smoothly, making sure that power gets to where it needs to be, making sure that the grid is balanced. So these are really important institutions for making sure that the electric power sector works well. And they're also very important in terms of the size or scope of their business. About 2/3 of the electric power that flows through transmission lines in this country is in fact controlled by RTOs. Now that of course doesn't cover the entire country, as you can kind of see from this map. There are regions that have persistently resisted the creation of RTOs, the Southeast and the Intermountain West in particular. There's always chatter about both of those regions developing an RTO to better coordinate the electric power grid in those regions. But because of where population happens to be located, the places that do have RTOs are doing a lot of the business and the organization and coordination of the electric power sector. So incredibly important institutions. Now, I mentioned earlier that they are private organizations, usually nonprofit corporations. They do have an interface with government decision makers, and it's important for me at the outset to specify that. RTOs do have to file tariffs with the Federal Energy Regulatory Commission, or FERC, that lay out the rules of accessing the system that RTOs are running, and develop market rules for how various markets these RTOs operate are going to work. And effectively, FERC has to be sure that these filings, that the policies that are developed by RTOs, by these private corporations, are just and reasonable under the Federal Power Act. So, FERC has always reviewed what utilities are doing under that standard. It also reviews what RTOs are doing under that standard. Now, because of that interface with FERC, RTOs are subject to some degree of review, both at FERC and then also ultimately in the courts, where FERC approvals or denials of RTO policy changes could be challenged in court. So that is a possibility, but it's really important at the outset just to note that the review that actually occurs is, by all accounts, extremely deferential. Right, so Emily Hammond at GW has written about the phenomenon of double deference for self-regulatory organizations that are only loosely accountable to public regulatory agencies. Effectively, courts are very hesitant to get in the game in reviewing agency decisions reviewing self-regulatory organizations. Obviously, I'll talk about this a little bit later, but the record that comes out of self-regulatory organizations is not really well developed enough for either the agency or the courts to engage in very stringent judicial review of what these organizations are doing. So it's really important to keep in mind that although there is this connection to sort of the public side of things, RTOs are given a lot of discretion, a lot of space in which to make policy. Okay, so here's where we start to get into our contribution to the literature and our argument. Effectively, the policies that RTOs are developing were developed to deal with what we call the energy dilemma. Okay, so the energy dilemma is two parts, as the name would suggest. One is reliability and one is affordability, right? So classically understood, the challenge for RTOs is to keep the lights on and to keep power relatively cheap as it can be, so that it's just and reasonable pricing under the Federal Power Act. As people in Texas will no doubt know, the reliability side of things is a really important role that RTOs play. It's something that's very much on their minds all of the time. And when things go very wrong, as they did in Texas a couple of years ago or a year ago, what was it? It was a year ago, right? Yeah. Then people will lose their jobs, right? This is really kind of #1 priority for RTOs. I mean, the name reliability is actually in ERCOT's name, right? So this is something they take very seriously. And balancing the grid, keeping the lights on is a very technically fraught task. And so this is definitely something that they invest a lot of energy trying to make sure they get right. On the other hand, you could have perfect reliability if you spent inordinate amounts of money, right? If you built excess transmission capacity, excess generation capacity, you could basically guarantee that you have reliability, but that's not going to protect consumers who are ultimately going to be responsible for those costs. So the RTOs have always balanced the imperative for reliability with an imperative to keep costs low. This is a difficult balance for sure, but it's one that, there's probably a technical solution to. Largely what RTOs have come down on is, running energy markets, including capacity markets, to make sure that there's enough generation that's actually online in the future to meet future demand. But that will also keep the prices low, provide an incentive to try to promote the lowest cost energy. So RTOs are, able to kind of navigate this energy dilemma fairly well. At least maybe that's a somewhat controversial statement, but the dilemma is solvable in a lot of ways. Now, the energy dilemma, though, is not an accurate picture of the true range of considerations that need to be brought to bear to run the electric grid anymore, at least. So what we argue in the paper, and we're not inventing this term by any means, is that RTOs are effectively engaged in navigating an energy trilemma. We argue that we're in the energy trilemma. So what is the third leg? What are we adding to the dilemma? Effectively, sustainability, right? So instead of just affordability and reliability, we're adding in the clean energy transition. We're adding in sustainability. We're adding in climate change policy. All of these things that are obviously something that we're all concerned about and trying to facilitate. But it's really important to note that that's not easy to resolve with the traditional dilemma, right? So adding that third leg really matters. So a couple of examples to generate or to demonstrate the problem. So example one, coal generation, coal power generation can be incredibly cheap and very reliable, right? But it definitely isn't green by any metric. And it's being driven out of the generation mix, because of a mix of factors. One is because the prices are becoming, less attractive, but also because of environmental policies that are promoting a clean energy transition, both at the federal level and at the state level. So, it's not possible really for coal to maintain its ascendant position when we add in that third leg and consider sustainability as a desirable policy goal. A second example, kind of cutting in another direction, but showing difficulties with the trilemma, is renewable energy. And we'll just take solar energy as an example here. Obviously, solar energy, very green, very in line with the overall goals of the clean energy transition. But the reality, and we have to be real about this, is it's not all that cheap, at least not if we're not going to make investments in a lot of storage capacity, interstate transmission lines that could shuffle power across the United States. Those kinds of things, those kinds of investments would have to be made to make solar energy a really desirable and cheap form of energy. Otherwise, we're going to have reliability problems, right? Because at the end of the day, both solar and wind are intermittent energy sources. You can run the grid with a lot of them, but at some point, there are going to be reliability issues because the sun isn't always shining, the wind isn't always blowing. So if an RTO is trying to consider how to balance reliability, cost, and sustainability, it's really difficult to figure out exactly what the balance is, how much we should be pushing solar energy. So what's the bottom line here? I mean, we're not trying to say, one particular form of energy is better than another, or to criticize particular decisions that RTOs are making. Our larger point is just that trade-offs have to be made across all three dimensions instead of just the two traditional dimensions. And yet RTO governance was really designed just with the dilemma in mind. So, these trade-offs that RTOs are increasingly being asked to make are not the kinds of things that RTOs have traditionally done, and that's causing problems, what we would call a democracy deficit. So why does the democracy deficit result? Well, it comes down to the basic design features of RTOs. At least that's our argument. So we argue that we can learn a lot about RTOs by bringing in this concept of corporatism, which is a core concept in the comparative literature on democratic institutions. I'm a political scientist, so I had to learn this stuff at one point. And when I first saw RTOs, I immediately recognized what I was looking at as a very rare example of corporatism in the United States. As I'll talk about in a minute, it's very rare to see something like the corporatist design of democratic institutions, or governance institutions in the United States. Much more common in Europe. So what is corporatism exactly? There's a really complicated definition that's offered by Philippe Schmitter. I won't read all of that, but bottom line, you can kind of distill it to three basic features. One is that corporatism defines and structures interest group participation so that certain stakeholders have a representational monopoly. So we've got a bunch of stakeholders or interested parties. Corporatism gives those parties complete control over decision making and excludes others who are not given that representational monopoly, right? So there's effectively a picking and choosing of what are the relevant stakeholder groups, the relevant interest groups, effectively, those are the only groups that matter for decision making in a corporatist institution. Second core feature of corporatism is that there's usually a delegation from a government entity to these stakeholders with a representational monopoly of a lot of governmental power, right? So, And this is, as I'll talk about in a second, very clearly the case with it when it comes to RTOs, where FERC is effectively giving a lot of policymaking discretion to RTOs. But that's the core feature of, or one of the core features of corporatist institutions, is that they end up with a lot of government power being exercised by a private entity that is composed of different stakeholder groups. A third core feature of corporatism has to do with sort of the process of decision making within the institution. So we've got these this representational monopoly by different stakeholder groups. We've got a substantial delegation of authority to that institution. The third piece is we end up exalting consensus as the overall goal of the institution. So there's a recognition that stakeholders might disagree about things, but the hope is that by limiting participation just to those peak interest group, stakeholder groups, we can effectively get to a consensus by forcing them to negotiate with each other. So there's a real premium put on consensus-based decision making, much less of an emphasis on sort of adversarial processes for decision making. It's a very deliberative democracy kind of model of things. So those are the core features of corporatism. And like I said, these are this concept of corporatism is really mostly associated with small democracies in Europe. The one exception to that, and this is kind of where my interest in administrative law comes in, negotiated rulemaking, which some of you may be familiar with, is oftentimes associated with corporatism in theory. Negotiated rulemaking is effectively I mean, you can just go down this list of the three basic features of corporatism and see it in that institution. This is when agencies bring together stakeholders, a select group of stakeholders, tell them that they can draft a rule together on a consensus-oriented basis. Really, it's quite obvious that that is kind of corporatist motivated. So if you want to think of negotiated rulemaking as an example, I think you'll see analogs in what we're seeing in RTOs. So yeah, let's talk about that a little bit. Taking this model of corporatism and bringing it to bear on the structure of RTOs. And there's much more detail in the paper if you're interested in reading up on it, but we see, both early FERC orders and later actions by RTOs themselves as really ensconcing this corporatist design in RTO decision making. So early on, FERC in a series of important orders, most importantly, Order 888 and then Order 2000, really restricted the definition of market participants who would have a role to play in RTO decision making. So in Order 888, they said that their goal in setting up these RTOs or encouraging these RTOs was to prevent the control and appearance of control of decision making by any class of participants. Of course, class of participants presupposes a definition of participants. So in Order 2000, they resisted, and I'm talking about FERC here, they resisted broadening the definition of class of participants to include other kinds of interests beyond the industry itself. So utilities, transmission owners, and independent power generators, end users. And by end users, we mean big industrial end users, not necessarily consumers, right? Consumers, as I'll talk about later, really have very little opportunity to be involved in most RTO decision making. And that's really kind of the core feature of corporatism as we see it, is that there's sort of, again, empowerment of, industry stakeholders, the various subsectors of the electric power sector, but really an exclusion of consumer groups, environmental groups, and other interests, including states, as we can talk about later as well. Order 2000 definitely resisted trying to broaden that definition of what groups must be included in RTOs. There was sort of a goal to limit the scope of participation just to a small set of stakeholders. And then finally, in Order 2000, there was also a pretty clear expectation that limiting participation to just these small groups of stakeholders would effectively allow things to be decided on the basis of consensus and would avoid a lot of unnecessary dispute at the FERC level and in the courts. FERC believed that RTOs were going to be able to handle things on their own. They would be able to get those relevant stakeholders to the table, have them go through a negotiating process, and then hopefully there would be nothing to complain about. Everybody would just kind of be happy with the end result. Now, following up on all those foundational FERC orders, RTOs have gone even further, we would argue, in developing corporatist procedures. So, we're most familiar with PJM because we happen to live in the PJM region, but it also is a really good example of this. PJM has designed its decision-making process in what it calls the consensus-based issue resolution system, CBIR. The idea of CBIR is to, again, get all of those relevant stakeholders to the table and engage in a very concerted negotiation. It can take a very long time, but the end goal is to advance one position that is ideally one that strikes a balance with every relevant stakeholder who's actually given a seat at the table. So you see that consensus orientation in PJM's own internal procedures that they've developed beyond what FERC has mandated. We also see corporatist elements in the ways that many RTOs have developed weighted sectoral voting schemes. So once things get beyond the committee system and a proposal actually goes to the full board, there's usually some kind of a weighted sectoral voting. Each subsector of the electric power sector gets a certain power in that voting. In PJM, it's 20% for various different subsectors. And all of the relevant members of the RTO then will, according to that scheme, weigh in on what they think about what the committees have produced. Usually, there's a great deal of consensus around that because they've gone through the CBIR system. But the idea of giving weight to certain subsectors and defining what those relevant stakeholder groups are is, again, very consistent with corporatism, we would argue. And then lastly, what I said earlier is really important to emphasize. There are exclusions, lots of exclusions of groups from all of these processes. So it's not the case in every RTO. California is a good kind of counterexample to this. But in most RTOs, civil society groups and states do not play a formal role. So again, we're familiar with PJM. The states do not have any formal membership or rights to vote in PJM. Neither do environmental groups or consumer groups like Public Citizen. They have some ways of accessing the board informally, and they've ironed out some agreements with the board to facilitate kind of behind the scenes meetings, but there's no formal participation in any of these processes. That's really reserved just for, like I said, the subsectors of the electric power sector, transmission owners, independent power generators, utilities, and the like. Okay, so now, why do we care about corporatism? Well, it's largely because corporatism interacts with the energy trilemma in a really negative way. And that's what we argue in the paper. So, we talked earlier about the energy trilemma. Now you have a good sense of what corporatism is. You put those two things together and it just ends up in dysfunction a lot of times. So a couple of examples for you to kind of illustrate the problem. So I don't know how many of you are familiar with the minimum offer price rule, the MOPR saga in PJM. The basic problem there was, with capacity markets, PJM wants to plan for the future, get future capacity to commit to providing that capacity at a future time. But those capacity markets were allegedly being undermined by renewables bidding into capacity markets at a very low price. So because renewables have very low variable costs of energy, they have a very low bid typically in the PJM capacity markets. And what that was doing was making it impossible for more fossil fuel-oriented generators to clear the market, right? So effectively, the future energy generation mix was not going to have a lot of fossil fuels in it if we operated the capacity markets without a minimum offer price rule. PJM started to get concerned about that because they worried that if we don't have enough fossil fuel generation in the future, which is more reliable, right, at least according to PJM, then we might have reliability problems down the road, right? Even though we're helping with cost, perhaps, to consumers, and even though we're clearly helping with clean energy and sustainability, right? So effectively, PJM was exalting the reliability concern over the other two legs of the energy trilemma era. So what did PJM do? It set a minimum offer price for certain forms of energy generation, subsidized energy generation. That would have been largely wind, solar, renewable energy. And what that would have done was it would have prevented those energy sources from bidding into capacity markets, below a certain price. And that price was going to be higher than the market was typically going to clear with conventional fossil fuel generation. So, at the end of the day, PJM was effectively going to raise the price that consumers were going to pay, and it was going to disadvantage renewable energy substantially. But it was going to get a reliability benefit. At least that's what PJM believed was going to happen. Now, there was a huge pushback on the MOPR rulemaking for obvious reasons. It's not clear how this could possibly be just and reasonable under the Federal Power Act. Also, it just seems very much in tension with state policies that are subsidizing renewable energy. The states have a lot of discretion to support whatever energy sources they want to support. So arguably, this was running into some preemption issues as well. There was litigation filed. It eventually didn't really go anywhere because FERC kind of buckled under the pressure, and PJM buckled under the pressure, and decided to roll back their proposed minimum offer price rule. And that's where things currently stand. But it was pretty avoidable from our perspective. The pushback that PJM got was entirely predictable. Yet we would argue that its corporatist processes insulated them from full scrutiny of the proposal at the initial stages when they were developing the minimum offer price for renewables. So at the end of the day, there's no way you can prove the counterfactual, but had RTOs not been so corporatist, had they had a more inclusive group of participants helping to make decisions, providing information, it seems reasonable to assume that they might have made a very different decision. They might have felt more pressure at the initial stages of decision making. So this is one of those things where it's sort of like we ended up in a good place where the MOPR went bye-bye, but it kind of took too long to do that, and it was kind of lucky, right? In a lot of ways, it took an extraordinary push to get PJM and FERC to abandon this. So second example, and I'll try to be relatively quick here because I know we're kind of running a little shorter on time than I expected, but another really key policy question that a lot of RTOs are navigating right now has to do with building out transmission lines. I mentioned earlier that with renewable energy, most experts believe we're going to need a much more developed interstate transmission grid to facilitate incorporation of those renewables. And so a lot of RTOs are being asked right now to approve projects, to develop processes for building interstate transmission lines to really speed that up. But again, we see RTOs, corporatist RTOs, kind of dragging their feet around this. And we would argue that there is a connection there. So just an example here is the SOO Green Line. This is a merchant transmission line proposed to bring wind power from the MISO region to PJM. So, the Green Line that you can kind of see here was going to bring a lot of wind power out from, Iowa, Minnesota, and allow that to access markets in the PJM region. But PJM ended up throwing up roadblocks to this proposed transmission line, which is going to be built for profit by a merchant transmission developer. So, very little financial risk for ratepayers or anything like that. But PJM nevertheless resisted it. It's a complicated story. I won't say much more about it here, except that the reasons that PJM gave for denying approval for this SOO Green Line were pretty obviously weak. And the record for the decision was non-existent, right? So effectively what happened was SOO Green went to PJM to try to get this permission, try to get a rule change that would allow PJM to do it, because PJM believed that they didn't have authority for it under their own rules. PJM just essentially said no and didn't really justify its decision in any way. We would argue that that's indicative of corporatist procedures, right? There's a lack of opportunity to challenge what PJM is doing to develop a record in an adversarial process. The only entities that really were involved in decision making are the PJM board, and of course all of those industry subsectors who have formal representation in RTOs, right? So a lot of those industry subsectors have no interest in developing more transmission lines. So it's really not surprising that they resisted the proposal to develop the SOO Green Line. But we, again, just like in the MOPR context, we believe that, had there been more open, adversarial, inclusive processes, perhaps PJM wouldn't have been able to get away with just flippantly saying no to what SOO Green was proposing. Okay, so I think, hopefully we've made the case that there are dysfunctions that arise from the confluence of the energy trilemma and then also corporatist design of RTOs. What I want to end with is some suggestions for how we get out of this mess. In the literature on comparative democratic governance, the foil to corporatism is pluralism. And again, there's a really complicated definition of pluralism offered by Schmitter. These are ideal types, right? But if you really want to distill it down to its essence, pluralism is really a rejection of the structured participatory model of corporatism. Instead, it sort of opens things up to all comers and encourages an adversarial process between stakeholders with divergent interests, right? So where corporatism seeks consensus, tries to limit participation just to a very structured set of stakeholders, pluralism throws open the floodgates, allows any comers to state their concerns, allows them to fight it out with each other, and then hopefully has a government decision maker in the position to be a neutral public arbiter of stakeholder positions. So pluralism, if you want to think of a model for this, is really kind of how we do administrative law generally in the United States, right? So, I talked about the negotiated rulemaking as an exception. The normal way of doing rulemaking, the normal way of doing administrative law is to really loosely structure public participation and allow adversarial processes to play out. So how would we do that? Institute pluralism in RTOs. We have a bunch of suggestions in the paper. Some of these may be good ideas, some of them may be bad ideas. There's really not a lot of way to know because we've never tried to roll this out in RTOs, but And one thing I should say is, the Office of Public Participation, OPP, that was just created by FERC, could play a pretty significant role in maybe trying to experiment with some of these pluralist reforms. So one of the motivations of the paper actually was to try to get OPP to think about, moving RTOs in this direction towards pluralism and away from corporatism. But we think there's probably, at least 3 pluralist reforms that could significantly improve RTO decision making. One would be something akin to notice and comment rulemaking, like administrative agencies have to engage in. So what's so great about about notice and comment rulemaking? It's largely about the duty to provide reasons in supporting a decision in response to the concerns that commenters are raising, right? So if you think about notice and comment rulemaking, again, anybody can comment. And the beauty of it is that, the agency that receives comments has to respond to every single comment that is salient and important with a reasoned justification for ignoring it, if that's what they want to do. And we think that could really improve RTO decision making if, again, we had an all-comers policy. Anybody can file a comment on a proposed RTO policy, and then the RTOs actually had a duty to respond with reasons to those comments. That could definitely help a lot, we think. Kind of related to that would be transparency and formal records. So if you think back to that SOO Green Line saga, one of the problems for FERC review and for judicial review in that case is just that PJM never really had to formalize anything. The record of decision is non-existent. All we really have is PJM's responses, to the complaint. But it's clear that there's a lot more going on that we just simply don't know. This is completely contrary to decision-making in any other public utility commission kind of situation. It's completely contrary, by the way, to what FERC would normally require if they were dealing directly with utilities, for instance, right? So we think that RTOs, when they're making policies for regions, for electric grids in an entire region, they should have to formalize the record of decision and be transparent about the full basis of the record, much as agencies would have to do in dealing directly with regulated parties. Third pluralist reform that we think would be quite helpful would be if it was a lot easier for outside parties to follow what's happening in RTOs. What's on the agenda? What is the RTO considering? Some RTOs are pretty good at this. California ISO is kind of a special RTO in a lot of ways, but it's pretty good at this. It tracks agendas. It has a very usable website. For a lot of other RTOs, though, it's almost impossible to track what's going on unless you're an insider. So we think that there would be a lot of appeal to something like the unified regulatory agenda that agencies are required to develop, where they indicate to the public, hey, we're considering taking on this issue, making this policy change, and people can track that in a central website. There's really no reason that we shouldn't have something as usable as the unified agenda in the RTO's own operations. So like I said, we think that the Office of Public Participation, I guess we wrote Office of Public Policy here, which is a typo. Office of Public Participation could possibly push RTOs towards these and other reforms. At the end of the day, though, OPP's authority may be somewhat limited under statute. So we ultimately encourage, in terms of mandating any reforms, it can certainly suggest whatever it wants to and study whatever it wants to and try to reform things just by persuasion, right? And that's kind of what we encourage them to do. But when it comes to mandating something, it may well be that OPP lacks any authority. And so we suggest in the paper that maybe FERC needs to write a rule that would give them this authority, or maybe even Congress needs to come in and give more explicit legislative authority to OPP to mandate some of these reforms. And I think I'll leave it at that. Obviously we are in some conversation with Shelley Welton, who's done a lot of work on this. I guess maybe I should just say one thing about her work, which is, if her sort of bottom line is that we may need to just make RTOs entirely public. We might need to just turn them into a government agency, that would be subject to ordinary administrative law. We're not quite convinced that we need to go that far. We think it's possible to have pluralist institutions in a private self-regulatory organization like RTOs. I'd be happy to talk more about that and how we see that sort of happening, but we don't see any reason to go all the way to full public governance of the grid when you can just institute pluralism and solve many of the problems within a private organization. And frankly, we think that that might be less disruptive to existing operation of the grid, receive less pushback from industry. So I think that there's a possible sort of golden arrow here to solve a lot of problems with a move towards pluralism while not fully abandoning the private governance model that RTOs represent. So that's all I have. I want to say thank you for listening to me today. And we definitely welcome follow-up. Our emails are up on the board here. Like I said, Andy can answer all the technical questions. So definitely follow up with him if you have any. Thanks.
Thank you, Professor. I really appreciate that. That was super fascinating. If you want to stop share of your screen.
Sure.
And maybe we could have a little conversation. We have about 10 minutes left. No question, I'm going to have some discussion. There you go. So here's the CLE course reporting information for those of you who need it. So we'll leave that up for a minute here so that you have it. And then, okay, so I'm sure that I have a couple questions from the audience. I do have one question, and I hadn't really considered it until you mentioned something. But so what is the role of the states? You said that the states aren't really involved in much in the decision-making either. And I think that that's interesting, and I hadn't really ever considered that, but they're the ones that are making the decisions for eminent domain and some of the other things that have to happen for these transmission lines. And so can you just briefly, maybe talk about what role you think that the states should have? I understand the public in general, but what about the states? Mm-hmm. How have they been left behind, and what do you think that their role should be?
Yeah. Thank you for the question. I guess from my perspective, as you mentioned, states are making all kinds of important decisions. It's not just eminent domain; it's also things like renewable portfolio standards. They have traditionally, under their police powers and under the division of authority under the Federal Power Act, had great discretion to kind of determine a lot of fundamental questions about what the grid is going to look like, or at least what's going to power the grid, what forms of generation we're going to have. I think a large part of the problem with RTOs is that they are trying to make these decisions in a way that preserves regional grids and policies to support regional grids that go across state lines, but states still have that legitimate authority to determine a lot of things about how the grid is going to be powered. So there's a kind of mismatch of the governance level, right? Because we're operating at the regional level versus the state level. At the regional level, it makes a lot of sense that we would have RTOs. The way power moves on the grid, it is a regional grid, right? So it's totally understandable that we would have RTOs kind of thinking more at that level, right? But they still need to be thinking also about the rightful authority of the states to determine the generation mix. And that is arguably where RTOs have, at least RTOs like PJM, have had some trouble, right? Again, like I said in the talk, they formally have excluded states from decision-making processes And they've also often made decisions that are in a lot of tension with what states are doing. So there seems to be a gap there where if states had more of a role to play in the actual decision-making process, we would get different decisions, right? So I think that that's a really important thing to keep in mind here. It's not just about opening the doors to public interest groups, environmental groups. It's also kind of a federalism question here, and RTOs arguably haven't been totally sensitive to that, I think. Again, I don't think we want to do away with the regional model, but I do think we need to acknowledge that there are legitimate interests there and bring those interests to the table in a more pluralist give and take.
Great. Professor Ferry, Stephen Ferry.
Okay, thank you. And thank you very much, Daniel. This is interesting stuff. And thank you, Gina and Aubin, for holding this and opening it up. Yeah, it is. Your last point is interesting because obviously the states have tremendous power. The renewable portfolio standard provisions in various states can raise, especially if they have certain renewable carve-outs, like solar carve-outs, can raise by 5 to 10 times the value of the power compared to some of the fossil units. And net metering, which more or less 40 states have, can raise it as much as 5%. So there's a huge influence that states have directly and indirectly there. A lot of questions, but let me just go back to this. I think you finished off by saying that the state siting issue, which obviously is critical. There have been a number of states, not only PJM, but a number of states in the past that have blocked power coming into certain areas. Recently up here, I'm in Boston, but recently there's been a lot of controversy trying to get Canadian hydropower down. New Hampshire's blocking it, Vermont's wrestling with it, et cetera, et cetera. Oftentimes because they see no benefit to them because it's coming through the states to bigger, more urban areas. Let me ask you this: have you given? Maybe no one on the panel here or on the link here has thought about it, but I believe the Biden administration infrastructure bill is going to try to override that for certain transmission corridors, if I recall correctly. And that's going to obviously get challenged. A somewhat similar law was challenged a decade ago, and the two appellate courts that looked at it said you can't do this. The federalism is a straight federal state split, and on facilities, the states have control as to what comes through their territories. Does that solve any of this? If the federal government, if it gets past litigation in the next couple of years, can slowly sort of override the states? I think it's questionable whether it holds up. But does that solve this, or not? Do you think?
Yeah. Thank you for the question. Yeah, no, this is very helpful to think through the kind of federalism dimension here. It's not a centerpiece of the paper, and I guess that kind of gets to my my response, which is I don't think it completely solves the problem, because we see this as a broader a problem of democratic governance. It's not just that states are being excluded, of course, but public interest groups, environmental groups, and so on. Could it solve the state versus RTO issue? If we have, kind of targeted, preemptive provisions in federal law, like in the infrastructure bill, maybe. I think, the example we gave, the SOO line, and many other transmission fights, like the one you mentioned, I think, yeah, if there was more of a federal role to play in kind of citing and approving those lines, in addition to planning them, just taking that away from the states, then the RTOs could sort of say, well, this is our domain. States don't have a legitimate role to play. You may be right, though, at the end of the day, that states are so used to having some control over these decisions that we're going to have some pretty pitched federalist fights in the courts about whether this legislation can survive. But assuming that the legislation survives and that we have, kind of fast track approval and citing authority, lodged in FERC in these transmission corridors, then yeah, I think, RTOs and FERC are going to have less reason to incorporate the views of states. Should they do it as a matter of good practice? Probably. But I think the key to our argument here is, when there is actually a legitimate interest, when people's interests are directly affected, they should have a seat at the table, right? Yeah. And as it currently is, states clearly do have that interest.
Yeah, and let me ask you just quickly about the shape of that table, or who comes to that table, because you mentioned earlier, I think, that if it became more governmental, and obviously that helps with some of the transparency that you're talking about, because then somebody could get a transcript or a recorded decision, and it could be disseminated more. What does that mean, do you think, if it becomes more government-like? Oftentimes, public involvement with stricter government agencies is only in an advisory capacity. They don't always necessarily get a vote. Would they still get a vote? Or would, if it becomes more governmental and more formal, does it have to be the government itself that makes the decisions, which I guess would be the ISOs as delegates of FERC, right? They're basically mini FERCs in sort of a exaggerated sense in some ways. What does that mean? Does that change? Does that change the ISO model now, where certain member groups at least can come to the table, although most of them, other than utilities, never have time to come to the table because the table meets so often, you know?
Yeah. I think, as we envision it, some of well, maybe all of the voting would go away. I mean, we kind of view notice and comment rulemaking as a perfect substitute for the kind of corporatist voting schemes that currently exist. So I think ideally, at least from my perspective, I can't totally speak for my co-author on this particular issue, but I think you could kind of do a one-for-one swap. And I think that would be better in a lot of ways, to just have, ISOs and RTOs be effectively mini FERCs, as you said, taking public comment and then rendering a decision without, tallying votes of any kind. In administrative law, we don't treat comments as votes. And I don't think you would want to treat comments as votes here either. I think you just get away from that structure entirely. Is it possible to imagine moving more in a direction of a pluralism without completely jettisoning the kind of voting structures, the sectoral weighting, all of that stuff? Maybe. I don't think we're saying that you have to do it all one way or the other. I think our larger goal in this paper is just to get people thinking about the different models of democratic governance that are potentially on the table here. Some kind of mix of procedures would be an improvement from our perspective than just simply going so far down the corporatist road. So I don't want to speak for my co-author. He might think maybe we should be a little more pragmatic and have a mix. I think it would probably be better to just go all the way with a more pluralistic adversarial model. I think we get better results that way.
Okay, thanks.
All right. Well, thank you so much. This was a really interesting discussion, and I really appreciate the time that you spent and the discussion that we were able to have. So there are additional, there's additional information in the chat. There's the article itself, and then the contact information for the authors. So thank you again, and thank you to everyone who is watching, and we will see you next time.
Thanks so much.